Call the meeting to order. Excuse me. First item of business is to open the hearing on House Bill 2629. Supervisor Wagner, brief us, please.
Thank you, Mr. Chairman. Committee House Bill 2629 removes mandatory jail time for a habitual violator convicted of driving while the driver's license of the person is canceled, suspended, or revoked. KSA 8-287 provides that a person who drives a vehicle while the driver's license of the person is revoked for being a habitual violator is a Class A non-person misdemeanor. That person becomes a habitual violator as it is defined in KSA 8-285 if they are convicted of driving on a suspended, canceled, or revoked license 3 or more times. Upon the third or subsequent conviction of KSA 8-287 or relatedly KSA 8-262, the person shall be sentenced to not less than 90 days imprisonment and fined not less than $1,500. What this bill would do would essentially strike the mandatory fines and jail time in KSA 8-287 and KSA 8-262 for habitual violators who are convicted of driving on a suspended, canceled, revoked license 3 or more times. The effect would be to continue to classify violations of driving while privileges to do so are revoked for being a habitual violator as a Class A non-person misdemeanor. You can see that in Section 2 of the bill. That classification is provided for in statute, carries a sentence of up to a possible year in jail and fines totaling not more than $2,500. And those sentences are determined by the court. I'd be happy to stand for any questions.
Representative Hoheisel.
Thank you, Mr. Chair. Thank you, Mr. Supervisor, for that breakdown. So just to put it in simplest terms, this just takes away the mandatory aspect of it. A judge could still sentence them with his discretion to imprisonment up to
A year and fines up to $2,500.
So under current law with the mandatory 90-day sentence, is a judge able right now to go above 90 days? Or is it a mandatory minimum of 90 days?
The minimum is 90 days.
So he could still go up to a year?
Yes, correct.
Okay. So this was basically giving the judge more discretion?
Yeah.
In the sentencing. Okay, thank you.
That's why I said.
Representative Syward.
Thank you, Mr. Chair. Not real good at understanding this. Is this taking the penalties and fines away or putting them on?
It's taking mandatory penalties away. So
They don't,
penalties are still available. It would still be a Class A non-person misdemeanor.
so they can have a habitual criminal, but there's nothing more than a slap on the wrist then?
Well, a habitual violator, if you're convicted of driving on a revoked license for being a habitual violator, then that would be a Class A misdemeanor and punishable up to a year and up to
Right. I
25.
want to make sure that was clear that the way I kept reading it, and I'm old and I had the shot, so I can't think real straight, but I just want to make sure I understood it. Thank you.
Representative Delperdang.
Thank you, Mr. Chair. How does this apply with a person who has been suspended from driving due to a DUI?
Separate. They're separate. This is just applying to offenders who drive with a suspended license.
So because of a DUI, my license is suspended and I go out and party again and I'm driving with a suspended license.
It's still,
And
it's tied to, the two statutes are tied together. So you first violate 8-262, which is the driving on a suspended license conviction. 3 convictions of that makes you a habitual violator. And in 8-262, this certain part that's being stricken, you can see it on page 2, lines 31 through 32. The mandatory parts are just taken out for being a habitual violator under KSA 288-287, which is just driving unsuspended. So DUI and everything that's not being affected here.
Okay. I don't know if I've quite got the answer, but I understand. Thank you.
Representative Hoheisel.
Thank you again, Mr. Chair, for a second time. Page 1, line 19, so section 3 there, except as otherwise provided by subsection 4 or C. Is that saying that if you have a second suspended on a driver's license, that's a mandatory minimum of 5 days imprisonment? Is that how I'm reading that? And will that continue to stay in there under this legislation?
Yes, you are correct. Yeah, and that continues to stay. That's for
So this proposal here would remove the mandatory minimum on the third offense, but continue to have a mandatory minimum on the second offense?
yes, I believe you are correct in that. But I might need to clarify that and get back to you.
I appreciate that. Thank you, Mr. Chair.
Any further questions for the reviser? Seeing none, thank you, Chris. Representative Helgerson.
All of you probably remember that Gail Finney had been pushing this for several years, this issue. And in Wichita, we found out a case where an individual was going through, paid the fines, but then was still subject to going back to jail. And they were told that that was what was required. This bill is in reaction to that small, narrow problem. And I apologize right off that I may have had it drafted too large. And we probably will have testimony later in this hearing from individuals that I respect, and they're about that they think that it's too broad and that we need to narrow the focus. My commitment to them and to the chairman is that tonight, tomorrow, we'll try to narrow the bill to do what was originally intended, not only by me, but also I think by Gail last year and the previous years, about trying to get those individuals back into a working environment. So I don't have an amendment now. I'm going to just make those introductory remarks, let the individuals testify. And it's my commitment that the individual, at least one of the individuals and whoever else testifies in opposition, and I will try to work on a compromise language to do what the original intent, not only of this bill, but of last year's bill. And
Representative Hoheisel.
Thank you, Mr. Chair. If I may address the ranking and just a quick question for him as the one who drafted this legislation. If I remember right, and I think if we're talking about the same story and the same individual in Wichita, which committee, this is a huge issue in Wichita. Just about half of the suspended driver's license in the state of Kansas are from Sedgwick County. It's something that we have to address. The issue I thought, or one of the issues I thought, was the individual's look back. So they looked back into his past and found 3 suspended on driving on suspended over a lifetime. And there was a proposal floated around to just have a 10-year look back, a 12-year look back. Does this address that any? The look back, how long you could look back for a suspended on or driving on suspended?
since since the conferee and I have not visited about specific amendment language that would be put in, we haven't brought up that issue. We know what we want to try to accomplish. We just haven't put it together. And that would be an issue that may possibly need to be addressed, whether or not you go back 5, 10, 15 years.
And Mr. Advisor, there is nothing about the look back in this legislation that was there.
That's correct.
Thank you. Thank you, Mr. Chair.
Okay, committee, we have a number of proponents and people that want to talk today, so we're going to limit everybody to 5 minutes. So we'll start with proponents of Tremaine Ingram, Kansas State Conference of NAACP branches. Welcome to the committee. At this point, we'll move on to Bobby Lytle remotely. Welcome to the committee.
Good afternoon.
Good afternoon. We hear you well. Thank you.
Yes, sir. My name is Bobby Lytle. I'm the one that has been on the news in Wichita and Sedgwick County about the driving on suspendeds. I thank you, gentlemen, for allowing me to have the opportunity to speak with you today. First, I would have to say that I am probably one of the most flawed individuals that you would probably ever have the chance to meet. And I understand that my life has created a lot of opportunities where I could have made better choices and I didn't. And in saying that, after getting out of federal prison for a while, I was faced with freedom and in trying to provide for myself and my family. I chose to drive when I knew that I didn't have a valid driver's license. I got 2 tickets, one driving on suspended from Sedgwick County, one driving on suspended from Wichita Municipal Court. And because of my history and my past, I was like, I knew that I had to do something to try to remedy the cycle that I had been in. And so for the first time in my life, I took a serious look at what I had to do within our society standards to try to conform to what a valid driver's license consisted of, which I hadn't had for 14 years. And in the process of that, discovering, and I got almost $15,000 in 4 jurisdictions that I had to pay. And any other time in my life, I'm rebellious, I'm hard-headed, totally against trying to conform. But in this instance, I realized I want to make some different choices and take some different paths. And in doing so, I committed myself to that. This was my priority in my life at this point. One, because I wanted to be a valid driver on our highways and not pose a threat or anything else of that nature to the community people around me. But secondly was I knew that I wanted to make a difference in my own personal life and my family and my home. And so I took 2 jobs, worked incredibly hard. And because of that, I've become successful. I have my own business. I'm recently married, and I just have had, by the grace of God, the most success I've ever had in my life. But being faced with that, I still had the 2 driving on suspendeds to deal with. It doesn't matter. They were wrong. Our justice system requires that. And Sedgwick County, once I came into, I paid this crazy amount of fines and reinstatement fees and tickets off. And Sedgwick County amended their driving on suspended ticket to no driver's license in possession and gave me a $130 fine. On the other side of that, the Wichita Municipal Court, they postponed it. I put this in for a year and a half, and they postponed it. As long as I was giving them money, they were fine with postpones. I paid it off. I get my driver's license, and as soon as I get my driver's license and I go for disposition with municipal court, I said, we don't care, and we're going to give you 6 months in jail. We're going to give you a $600 and some fine. We're going to suspend the jail time and give you house arrest, and then have your license revoked for 90 days. And I can't argue with you. I'm wrong within the framework of how this criminal justice system is. I deserve every bit of that, and I can't argue with that. But at some point, I would pray humbly that people that would come after me would be able to have the opportunity to have some discretion about how people are going about rebuilding their lives, how hard it has been to rebuild that life, and give people a chance and not have to necessarily be so punitive in regard to this. At this point right now, the only thing that I have to actually look forward to is going to jail, losing my job, my contractor's business. I have a child and a wife at home that I'm financially responsible for taking care of, and I'm a property owner. All that, taxes, everything. I can't do any of that. I won't be able to do any of that. And so where does throwing me in jail and punishing me solve anything about society's issues concerning this? I mean, if you want to be mad at me because of my past, granted, you know what? I've been a flawed person, very flawed person, and I deserve those attitudes, I guess. But I'm not just speaking for myself. I'm trying to speak for people that I know in our ministry on the street, that there is a real struggle out here for people trying to turn their lives around. And when you take that hope away, once they've accomplished that, I'm blessed. God is going to carry me through whatever it is I got to carry through. But there are people out there that aren't just, that don't have those support systems and don't have those remedies and availabilities. And there are real struggles. And as a proponent to this bill, if you make this discretion possible, you might unknowingly or willingly, you'll know it because it'll be your decision, that you've just helped thousands and thousands of people that are on the precipice of trying to do something really remarkable in their life and to be good citizens. And with that, I say thank you.
Are there questions? Seeing none, thank you very much.
Thank you, sir.
Next proponent I have listed is Wendy Stark, League of Kansas Municipalities, and I believe she's remote also. Welcome.
Good afternoon. Thank you, Mr. Chairman and members of the committee. Can you hear me okay?
Yes.
Okay, great. Thank you. And thank you for affording the League of Kansas Municipalities the opportunity to speak in support of House Bill 2629. Our support of this bill really stems from the enhancement of the judicial discretion, which is afforded by removing the mandatory sentencing for habitual violators convicted of driving while their license is suspended. Depending on the facts in the case, there are times when the cost of keeping someone in jail will outweigh the benefits. But judges should have the discretion to review the facts relevant to the case and levy a sentence that reflects this cost-benefit analysis. With that being said, there are cases when jail time may be the best way to protect and preserve public safety. Looking to the definition of habitual offender in KSA 8-285, some of those convicted have committed serious offenses against public safety. For example, 3 DUI convictions would make one a habitual violator under the statute, if convicted. Here, it may be in the best interest of the community to give this person some jail time to ensure that they are not on the road. Cities want the flexibility to determine what is the best course of action on a case-by-case basis. If House Bill 2629 moves forward, judges will still have the discretion to order jail time if they deem it to be in the best interest of the community. Judges will be able to weigh the facts of the case and determine what sentences will best protect their community. The League supports this judicial discretion and would ask that the committee recommend the bill favorably for passage. And with that, I can stand for any questions. Thank you.
Are there questions for Ms. Stark? Seeing none, thank you.
Thank you.
Next up, we have Mr. Jim Howell, Sedgwick County Commissioner, District Number 5. Welcome to the committee, Jim.
Well, good afternoon, Chairman Prowell. It's good to see you again today. I
Thank
see
you.
Representative Dupperdang is my friend as well. Good to see you both today. Members of the committee, I wanted to testify as a proponent for HB 2629. I became aware of a very large number of people on suspended licenses in Sedgwick County several years ago. There's been numerous news stories on this, and there's been efforts by several legislators over the years trying to remedy this. Last year, many of you voted for Senate Bill 127, and we celebrated that bill here in Sedgwick County. Unfortunately, it didn't solve all of the problems. Many of the things in that bill are discretionary, but it doesn't resolve a couple of points that are addressed in this bill today. One of those things, if you go to my third page of my testimony, you'll see a schedule of what is in the statute right now. And one of the questions I just heard earlier from one of the members of the committee asked about whether this would deal with how this impacts DUI. You'll see there, this is only the habitual violator conviction we're talking about. If you look at on a third conviction, and this is lifetime. So if you had a suspended license when you were 16 years old, and let's say you're in your 20s or 30s today, this is a lifetime look back. So when you say third offense, this is for the entire life. I would actually like to see an amendment to this bill that would limit this look back to 10 years. That would be a favorable amendment to this bill. But regarding the habitual violator conviction, we have roughly, I'm going to spitball a number here, somewhere between 70 and 80,000 suspended drivers in Sedgwick County today. And many of them are in compliance. They're not driving because they're doing the right thing. But some of them, they make a bad choice because they are desperate. They have to keep their job. They've got to take care of their kids or whatever. And they make a bad choice to drive. We know that's the wrong choice. What they really want to do is fix the suspension so they can drive legally. And I would ask you to consider, number one, the reason why these suspensions happen in the first place. Most of the time is for unpaid tickets. These folks had a speeding ticket in their past, couldn't pay the ticket, and had a suspension. And then because they didn't understand the consequences of driving on suspended, they got caught. The first time you do that, go back to that schedule on page 3. It's a $1,000 fine. Usually they will not do the jail time, but they'll put the fine on there. So usually it's no time in jail, but let's say 5 days minimum. They can usually do that other ways, but that $1,000 fine is almost always given. Second time they do this, it's $2,500 fine. Before you know it, they're in such a snowball situation they can never get out of this hole. And there are literally people in Sedgwick County that have 10 and 15, 20, even $30,000 worth of fines right now because they've been dealing with this problem for decades. And to think there's people who are not going to drive, I wish they wouldn't, but they do because they don't really have another option. And so, in a sense, this starts out as being unpaid tickets because of poverty, and it turns out to be a debtor's prison. In a sense, this is giving punishment to people by adding fines and adding suspension time as a consequence of making a bad choice. It doesn't really resolve the problem. Let me encourage you with another idea. On page 2, we talk about a better idea. The solution is a compliance-based approach. We do this with drug court, for example, here in Sedgwick County. If someone commits a crime, but they actually have a drug problem, and maybe that's a real problem, we can have them show compliance with requirements, and they can work off essentially those charges, and those charges eventually go away. So imagine someone that's, in this situation, they got caught driving, they had a ticket they didn't pay, they got a suspension, and the first time they get caught, they learn about the system. But rather than give them $1,000 fine, help them understand the consequences of their decisions, make them go to some type of compliance-based, community-based consequences for their decisions. At the end of the day, what we're doing right now does not work. We have, again, roughly 80,000 people in Central County that are driving on suspended. Most of them are not, hopefully not driving, but many of them are. And if they get caught in an accident, usually you hear people say, I had an accident with somebody who didn't have insurance. Most of these folks can't afford insurance. And so it just gets worse and worse and worse and worse. The problem started out, they didn't have money for a ticket. And then before you know it, they can't go to work, they can't pay for themselves, and there's absolutely no way for them to climb out of this hole. So I would just see a compliance-based approach to this would be a lot better. If someone's trying to do the right things, like Bobby Lytle mentioned a minute ago, it doesn't do any good to put him in jail at this point. He's done the right things. He's paid off his fines and fees. He's trying to get back on track. He doesn't want to lose his jobs. And yet because the way this law is written right now, there is no real choice for the court. They have to give him some jail time. And he has to stay home at least for 6 months and 90 days suspension added to his situation. He has his license today, by the way. He didn't mention that, but he does have his driver's license. This will add 90 days suspension to his license. So again, he can't drive once again. So this is just especially hard for some people in the community. It doesn't seem to really solve the problem. I think a compliance-based approach is a lot better. As a previous conferee mentioned, the judges do have some discretion still, even if this passes. This doesn't take the options away. It just simply takes away the minimum sentences go away. And that's what needs to happen. So with that, Mr. Chairman, thanks for the chance to testify. And I'll be glad to stand for questions at the appropriate time.
Are there questions for Commissioner Howell? Seeing none, thank you very much.
Thank you.
Next I have up Mr. Walt Chappell of Wichita.
Hello there, Chairman. Can you hear me?
Yes, sir.
Very good. I want to thank you and your committee for bringing this bill forward. It's long overdue. And it's good to see Leo sitting there next to you and other members of your committee. We have worked together off and on since 2012 to get some of these reforms into the law. And each time there's lots of objections from the courts saying, oh my gosh, we got to have more money from these folks. We have to pay our non-judicial staff, and we've got all these clerks sitting here pushing paper that, when a police officer stops somebody, they've got to have all the documents in the right folder. My point is not to be sarcastic, but to say that it's not a crime to be poor. Most of these suspensions, and there are over 200,000 of them that are in the state of Kansas, are folks who didn't have enough money to pay the original fine. Now, that fine normally would be $200 or $300 for the infraction as well as court costs. We're finding in the analysis we've been doing over the years that court costs keep going up. They're over $100 per case in Wichita now. So we have folks that are trying to pay that first bill within 30 days. And if they don't have the money saved to come up with that, then of course they have their license suspended. Now, if they can get to the court, they can take off time from work and not get, their job taken away from them because they missed work, then they may be able to get the judge to convince them, say, okay, give me some more time and maybe I can come up with the money. But to suspend a license to collect a debt, listen to that very carefully. To suspend a license to drive a car or a vehicle of any kind to collect a debt to the court is not something that any other part of our society will allow. I, as a business member, I cannot charge my customers an extra fine or put them in jail to collect an invoice. None of our farmers would ever think of that. We couldn't ever work together as a society if we held people in jail to collect debts. That's called debtor's prison. So we have a situation in Kansas that's got completely out of control. And to say after the third offense, you're going to go to 90 days mandatory in jail. You're going to have a $1,500 fine. I've heard today $2,500 fine. and make you a habitual violator, which means the license is now revoked. It's not just suspended, it's revoked. And it all started with that original stop. Now, we've done many analysis here. I've analyzed 135,000 citations in Wichita alone. There was a statewide analysis that was done by the state legislature in the year 2000. And all of those 5 or 6 different analyses have all shown that there's a disproportionate number of people being stopped in our state and given tickets for any number of things. There's over 200 different citations that an officer can claim the person violated. So they can come up with any reason they want to put down on a ticket. And that then is the responsibility of the person to pay whatever fine has been imposed by the courts for that particular infraction. My point is, how is anybody going to pay any fine, come up with any money, if they're sitting in jail? Why is it that we make it mandatory that a judge has no discretion and that person has to go to jail and sit there for 90 days plus have an additional fine on top of it? Now, I heard the testimony today in the House. You were talking about having an amendment to say we're going to take away any responsibility of the governor or the bureaucrats to come up with any rules or regulations. Well, I want to point out to you that municipal judges, at least in Wichita, are appointed. They're not elected. I want to point out that many times the regulations and the fines that are coming up with are not those that were set by the legislature, but were set by the courts themselves. And yet the people have to comply with them. I've also heard folks concerned about, well, we don't want to wear masks and we don't have any reason to be able to tell anybody to have a vaccination for COVID. But here we are saying, if you don't pay the fine we impose, we're not only going to say you're going to go to jail, but you have to sit there until you come up with the money. Now, the other part of the story is I've talked to the folks at the homeless shelter in Wichita. It's called the Union Rescue Mission. 85% of the men in that rescue mission are homeless because they couldn't drive to keep a job. They have no way to keep their family together. They lost their home. They lost their job. They have to be driven every place they go with the charitable contributions to that agency. This is going on all over our country because of the interstate compact. So you have a chance today to make a very significant decision. And I really compliment you for bringing this bill forward, and hopefully it gets passed and on the House floor by the end of turnaround. So this gets to the Senate. We have to take care of this one now. Please don't delay it. Make sure it gets done. And at the same time, as several people pointed out today, please take away the fines and the jail time, 5 days on the second infraction. There's no reason to fine people or put them in jail because they're poor. That just doesn't make a bit of sense, and it's certainly counterproductive. Thank you for your time, and I appreciate it very much.
Are there any questions for Mr. Chappell? Representative Seibert.
Thank you, sir.
Thank you, Mr. Chappell, for your testimony there and everything. I got a question from a constituent on this. Why did they keep breaking the law, though? That's the thing. They're habitual. So, there's a lot of people never get a suspended driver's license because they didn't break the law. But if you're in an accident with one of them, your insurance, it's kind of complicated. But by the time they did it 3 times, why do they keep breaking the law? That's my question.
If I could answer, I would be glad to respond. I think any of us will know if we need to go get groceries, if we have a sick child and we need to go to the hospital, if we have any need to take care of our own personal needs, like get to work, keep a job, be able to put food on the table. Those are all the issues that people are facing. And because the court says, well, you have a $200 fine you didn't pay, and now we're going to take your license away and make you so you can't go anywhere, that's like kidnapping somebody and putting them in a hostage situation. Say, well, if you don't pay us this fine, we're not going to release you. Now, as a society, we have more compassion than that. We don't need to do that to our fellow Kansans. This is no way to treat anybody. It's cruel and unusual punishment, and it needs to stop.
Any further questions? Seeing none? Oh, yes, Representative Ballard. Almost called you by your first name. I'm sorry.
That's my name. Thank you, Mr. Chairman. Mr. Chappell, what do you think is a solution to this problem? Is it this bill, or should we go beyond this?
You know, I'm so glad you raised that. This committee last year was very forthright in passing out of committee 2193. 2193 was a tremendous bill. It takes care of this problem and many others. For example, allows people to have the chance to set up a payment plan rather than have to take off work to go see the judge and have the judge look you in the face. Okay, you're going to pay this fine or not? They can call the clerk of the court in that bill and set up a payment plan, go on with their life, and the court's taken care of. There's no need to suspend any license. That bill also lifts the warrants. If you have a warrant for your arrest because you didn't appear, okay, the judge has the discretion to lift that warrant. My point is that 2193 needs to come back to the floor of the House. It was on the calendar March 5th of last year. It was pulled off the calendar because Sean Jorgensen over in the Supreme Court called the Senate Majority Leader, and he said, oh, we need $750,000 put in the appropriations bill. If you do that, we have no problem with the bill. But otherwise, we don't have any money unless we collect $100 per charge on reinstatement fees. Well, reinstatement fees was in 2193. It eliminated the per charge. It took it down to just $100 to reinstate. So yes, there's a lot more that can be done. And I hope that this committee will bring back 2193, get it out of your committee and back on the House floor so it takes care of a whole bunch of the other issues that are still out there that need to be resolved and can and should be done this session.
Mayor,
Yes, go ahead.
thank you very much for your response. I couldn't remember the bill, but I knew there was something about a payment plan, and I didn't remember. So thank you so much about that. And again, thank you for your testimony. Thank you, Mr. Chairman.
Representative Jacobs.
If I may direct the reviser, and he may not know this, just a question. How long is it if I get a ticket, what is the average time that I have to pay that ticket? Could you answer that question?
Thank you, Mr. Chairman. Not off the top of my head. I'm sorry. I'll have to look into that.
Okay. Thank you, Mr. Chair. The word in the last couple conferees came up, poverty, 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 but it's not just necessarily poverty. We're calling it one thing, but neglecting to call it something else. It's also called bad behavior, and actions have consequences. And someone broke the law, so someone has to pay for that infraction. And that may sound like a terrible thing, but that's the whole issue of this. Yes, payment plans or something like this, and that's the reason why I asked, how long does it take to maybe pay off $250? But again, I reiterate, actions have consequences. Thank you, Mr. Chair.
Representative Proctor.
Thank you, Mr. Chair. A question for Mr. Chappell. First of all, thank you very much for your testimony. My question is, are there other infractions that would cause, besides not paying your tickets, that would cause somebody to have their driver's license suspended that are covered under this bill?
I'm not sure I understood your question. Could you repeat it, please?
So in your testimony, you talked extensively about people who had their license suspended because they didn't pay their fines. Are there any other reasons that a person might have their license suspended that would cause them to fall under this recidivism or habitual offender law?
Oh, absolutely. Thank you for bringing that up. We have never supported any bill. In fact, 2193 specifically excluded DUIs. If you're convicted of a DUI, that's a whole separate animal. And those folks need to be kept from behind the wheel. They may have their thing, there's some bills in the Senate this session on breathalyzers. Make sure that they have a chance to have their breath checked before they can ever turn on the ignition. Those kinds of things can be put in by the judge and make it so they could drive, but only if they're not intoxicated. So DUIs is one. The other is a person that has a vehicular homicide conviction, where they particularly hit somebody or ran away, didn't stick around after they hit another vehicle or person. There are those specifics in this bill. I think you'll notice it, I think, on page 2, and those are excluded. The ones we're talking about here are failure to pay a fine. And that has to do with, in most cases, not having enough money. With the cost of everything going up, the inflation for food, for gasoline, for anything that you try to buy anymore, these people are poor and just having a hell of a time surviving as it is. And to lay on additional fines, we're finding here in our analysis in Kansas, there are people that have not had a valid license for 20 and 30 years, and partially because they have now $30,000 in fines. They've been pulled over often enough that they have had those accumulate. And we also have some officers, by the way, who have a pattern of sitting down at the end of the block. As soon as somebody pulls out that they know doesn't have a license, they will stop them immediately and give them another ticket. The same way on license plate readers. We're finding that some of the officers are using those here in Wichita and saying, okay, I know that person probably doesn't have a license, so here's my pretext. I'm going to pull you over because of such and such. And then as soon as they got you stopped, then they write you an additional ticket. And if it's the third time, they impound the car. So the person not only goes to jail, they have a $1,500 fine, but they have towing costs and storage costs to get that vehicle back. So many times people just lose their whole vehicle. They cannot, and that vehicle, by the way, is the only source of transportation for the whole family. It's not just that driver, but everybody else that depends on that vehicle to get to work or pick up groceries. So this is a snowball. It just gets completely out of hand, and it starts with not having enough money to begin with.
Thank you for that, Mr. Chair. If I could ask one more, I just want to make sure that I am confirming what I'm hearing here. There are no other offenses besides failure to pay fines for which a person would lose their license that is covered in this bill. Is that your testimony?
Well, I'm not sure I understood the question that well, but if you have a DUI or if you have a vehicular homicide conviction, you have no reason to get out of jail. You're going to sit there and you think about what you've just done. This bill only applies to folks who have not had enough money to pay the fine. Failure to pay the fine trips the lever within 30 days. If you don't have it paid within 30 days or have a payment plan worked out with the court, the Department of Revenue is notified to suspend your license. And many times people don't even know their license is suspended until they're pulled over and they, oh, by the way, you don't have a license. Here you go. Here's your fine and your jail time. That second time, by the way, is what, 5 days in jail. Now, for many people, that's enough to just lose their job immediately.
Thank you, Mr. Chair.
Representative Hilgerson.
Representative, in answer to your question, the intent of the bill was to be very narrow. There is a individual that will testify later on that believes that under this bill it's broader than that, and that is the willingness I am trying to make of coming up with an amendment that keeps it in a very narrow area.
Thank you, Representative. So, are there other offenses that are covered under this bill right now where people lose their licenses, or do you disagree with that analysis?
I think he'll testify on that briefly.
Thank you, Mr. Chair.
Any further questions? Hearing none. Thank you, Mr. Chappell.
You're welcome, sir.
Mr. Chairman, I did have a question.
Okay, I'm sorry.
Representative Hobson.
Go ahead.
Thank you. Thank you, Mr. Chairman. Thank you, Dr. Chappell, for your testimony. Are you able to give us a breakdown in terms of the demographics as to those who are having a hard time paying their bills with respect to their fines they're receiving for their driver's license?
Thank you for that question. As many of you know, I've been the vice chair of the Racial Profiling Advisory Board in Wichita, Kansas, and worked on this issue for some 23 years now. The patterns and practices of disproportionate enforcement of traffic laws is very, very clear. We have at least 5 studies now of the state of Kansas as well as here in Wichita that all verify that black drivers are twice as likely to be stopped to begin with. They're 3 times more likely to be searched, to have a physical altercation at the time of the stop, and or having to go to jail. Now, this is really concerning. When we looked at the data, Dr. Berzer and I, Dr. Berzer is at Wichita State University in the Criminal Justice Department, and I have been given the data from all of the traffic stops from 2016 through 2020. Those data show that black drivers are not only twice as likely to get a ticket, but 50% of the tickets that they receive are for non-moving violations. They have nothing to do with safe driving. They're non-moving violation. Now, the other thing that I want to point out is that Dr. Berzer's data showed for the 19 and 20, the 2019 and 2020, that half of the citations for driving on suspended were given to black drivers. Out of the whole city, all other drivers combined had just as many as the black drivers, but the black population in Wichita is only 11%. So because there's a disproportionate number of people stopped to begin with, then you compound that with the fact that many of these folks do not have a lot of income to start with, or have not been able to have a job. Can't, in the economy we've had, the recession and everything else, a lot of people are laid off. So it becomes a compounding problem, and it's just devastating for these communities. All because, first of all, you're black to begin with, and secondly, if you don't have the money to pay that 30-day, you're just up the creek. There's no way that this makes a bit of sense. So these kinds of punitive additional jail time and fines absolutely put people in a major crisis. I want to just bring back one more point. Many people in our country now and up in Canada, they're all upset about masks, don't want to have a vaccination, so forth. Well, you don't want the government to tell you what to do, right? But we're saying, all right, you have no discretion. We're going to tell you immediately, if you have no money in your pocket to pay this fine, we're going to put you in jail. And we're going to fine you some more. Now, we got a real problem, folks. We can solve it. This bill is a major step forward. And I really appreciate the opportunity to testify, but I hope you get it passed and on this House floor by the end of this February.
Thank you, Dr. Chappell. Of course, I did have additional questions with respect to what you just said, but your testimony right there is good enough for me. I appreciate your time. Thank you, sir. Thank you, Mr. Chairman.
Thank you. Any further questions? Hearing none, we'll move on to our next proponent, Sheila Officer, Chair of the RPCAB. Are you present? Don't believe she is, so may just consider that at this point written testimony. Next, I have Ty Wheeler, Project Director, Employee Office of Kansas Legal Services, and he is remote. Welcome to the committee.
Thank you. Thank you for allowing me to appear remotely. It's sort of nasty out there today. I have been the managing attorney, staff attorney, project director with Kansas Legal Services going on. It'll be 30 years this year. In Lyon County, Morris County, Marion County, we also have a public defender contract where we do some misdemeanor defense work. Under that comes driving while suspended, traffic cases. I have come to learn over my 30 years that driving while suspended, driving while habitual are probably the 2 most insidious charges my clients can receive in the traffic realm. That's because it affects their ability to drive, and there's a mandatory minimum. That means the judge can't look at the circumstances and decide this person belongs in jail and this person doesn't. If we've got a young man out here who's gone his 19th driving while suspended, he gets the same thing as a young lady who got her license suspended for failing to pay a fine. It's her third time. There's no discretion for the courts. I like cases where the judge can use the discretion. This doesn't decrease what he can sentence people to. The vast majority of the clients that I am dealing with who have driving while suspended issues or driving while habitual issues are here because they failed to pay a fine. They're not seeing me because, their license is suspended for a DUI. That occasionally happens. Very rarely are they here because they committed a vehicular homicide. It's a very small and narrow group that deserve to have some sort of mandatory minimum. The vast majority of the people are good people who just can't afford to pay their traffic tickets. If you've got a 22-year-old single mom of two who gets pulled over for a speeding ticket and a bad headlight and running a stoplight and, 3 or 4 offenses, you've got the court costs, you've got the fines on that, you've got those to get paid within usually about 30 days. If it's not paid by the time the court hearing rolls around, the court will end up issuing what's called a 30-day letter, and the Department of Motor Vehicles will suspend their license after 30 days. And oftentimes my clients don't know that because they fail to notify the DMV when they move. So that notice goes out to whatever their last address was, or maybe it's 3 addresses ago, and they get suspended. Next thing you know, they're driving to work and they get pulled over. And the discretion of the courts is very limited by the statute. Oftentimes, it's up to the discretion of the county attorney, the prosecutor, to figure out how to deal with this case. Our local prosecutor is more than happy to continue cases out quite a long time in order for them to go get their restricted license or go get their license back, and then we'll amend to 8235. Our local judge, at least here in Lyon County, he'll impose a $25 fine, court cost, and on they go. And they've got a chance to go get their restricted license and get back to work. I think somebody asked, why do these people drive? If they know they have an offense and know they've been suspended, why do they drive? Well, the choice is not drive and not violate the law, or go to work, pay your rent, have your groceries, support your kids, and take a chance of getting pulled over. It's not, a evil or a vicious mindset. It's a survival mindset. Our office and the county attorney's office, we sort of have a shorthand for specific cases, and those are the cases they haven't paid their fines. We call it driving while poor. If you've got a $800 fine that you need to pay within 30 days, I could pay it. Many of my clients couldn't. Many of my clients aren't sophisticated enough to know that they can call the court and set up a payment plan now. That just doesn't happen. Many of my clients don't know that they can call and get a restricted license. I think this is one of those areas where allowing the judge to have discretion of knowing who he should sentence to a year and who she should let go out there and drive again or try to get back to driving again. On a mandatory minimum sentence, the county attorney is willing to work with us to try to figure out how to avoid that, because they know when they send somebody to jail, it's going to cost Lyon County at least $9,000 to keep that person for 90 days. I think Lyon County charges, $108 per inmate per day. So at that cost, what is the cost the counties are having to pay to incarcerate these people who are doing nothing but driving back to and from work, to and from the hospital? I had a client a while back who was not driving, he was doing a very good job following the rules and restrictions. He's having his wife drive him everywhere. One night she went into false labor. He decided to load her up and take her to the hospital. When he got going there, he got pulled over. He was going a little fast, as understandably. And the officer pulled him over, followed him to the hospital, and then went to the hospital and gave him a speeding ticket and a driving while habitual, because it was his fourth offense for driving while suspended or revoked. We're looking at him doing a mandatory 90 days in jail. And the issue is he's the only support for his wife and now newborn child. It's just a question of fairness. Do we want to incarcerate people who are doing nothing but supporting themselves and taking care of themselves? I mean, I often look at it, then why are the DUI mandatory minimums the same as the driving while revoked or driving while habitual? You get the same thing. Oftentimes we try to be creative and work out some way to avoid the driving while suspended charge. I am more than happy to plead my client to a speeding case and something else to avoid the suspended case, because the suspended case will have effects on their license. I'm more than happy to have them pay a greater fine. I don't know what I would do if I lost my license for 90 days, but it would affect my livelihood. It would affect my social life. It would affect everything I do. I just think this is something that needs to be modified so that people who want to comply with the law can comply with the law, get their license back in good shape, go to work, get a job, and support their families. I'm just in support of 2629 and would like to see it pass. Thank you for your time. If you have any questions, I'd be happy to answer them.
Are there any questions for Mr. Wheeler? Representative Weigel.
Thank you, Mr. Chairman. Do you, under the HB 2629 or what's on the books now, if a person gets a driving while suspended, and then they get the I forget the term you used, to lessen the blow a little bit, maybe a smaller fine, or the fine is spread out more, restricted driving privileges. What all does that entail as far as restricted driving privileges?
As I understand it, when they apply with DMV, if they meet certain criteria, they can apply and get a restricted driver's license for a period. I think it's 2 years, and I know Marilyn is somewhere, and she can correct me on this. She's better versed with that. But for a period of 2 years, they get a restricted driver's license and allows them to go to and from work. I believe it's to and from treatment and to and from probation. And they can get out there and earn money with which they can pay off the fines they owe.
All right. Thank you. Thank you, Mr. Chairman.
Representative Minnix.
Thank you, Mr. Chairman. I would like your professional advice as to what you believe an appropriate deterrent would be for someone who is a habitual in this particular case.
Well, I think the current statute allows a great deal of deterrence. I mean, the judge, if he looks at somebody and says, your reason for driving was not a very good reason. I mean, if somebody comes in before the court and he gets caught driving to the liquor store to go pick up some liquor after he's been suspended before, judge is probably not gonna take kindly at that, and the judge has up to a year that he can incarcerate him. Judge, the problem is if the judge looks at somebody who is, a single parent, couple kids, and all they're doing was driving to and from work, and they weren't being reckless. They just got pulled over because, let's say, they had a tail light out or a tag light out, which happens all the time. Cracked windshield, failed to signal 500 yards in advance of or 500 feet in advance of a turn. it's very easy to get yourself pulled over and very easy to have them then run your license. We in the office play a game we call the Trooper Tucker game. Whenever we ride with each other, we see how far we go before there will be an infraction that he can pull you over for. Because he can even pull you over for if you're 2-3 miles over the speed limit. I've had clients pulled over for 2-3 miles over the speed limit. And oftentimes I know it's because the officer knows who's driving the car, whose car that is, and knows they've been suspended. Or knows that previously they've stopped them and found drugs. And lo and behold, they pull them over and they don't have a driver's license.
Okay, thank you. Thank you, Mr. Chairman.
Any further questions? Hearing none, thank you very much.
Thank you.
Committee, I would bring your attention to written testimony from Bonita Gooch, the community voice, and a letter from LaWanda DeShazer, community advocate, Wichita Racial Profiling Advisory Board. Does anyone else wish to speak as a proponent? Seeing none, I have one opponent listed, Mr. Ed Klump, remotely. Welcome to the committee.
Thank you, Mr. Chairman. Just check first, make sure you can hear me.
Yes, we can.
Okay, thank you very much. My name is Ed Klump, and I am testifying today on behalf of the Kansas Association of Chiefs of Police, Kansas Sheriff's Association, Kansas Peace Officers Association in opposition to House Bill 2629. I want to tell you our opposition is not to trying to address the things that proponents have been talking about with the issues surrounding being suspended, solely due to the failure to pay a fine or failure to appear in court. However, I am the one that Representative Helgerson has been talking about, that had a conversation with him earlier this afternoon. The bill as written goes way beyond that issue. It does, in fact, encompass other charges. There's another statute that's very relevant to this discussion that's not in the bill because it wasn't amended. And I took the privilege of adding that on the second page of my testimony, and it's KSA 8-285, which defines what habitual violator is. And the problem with this bill as it's written is that it removes these penalties for every case of violation, third or more violations in 8-287, and also in section 1, it removes the penalty entirely for any habitual violator. And there's a lot of ways to become a habitual violator, as you can see in the statute that I put on the back of my testimony, or on page 2 of my testimony. So we think there's a way that we can address what the proponents are concerned with without encompassing people who are habitual violators and continue to drive, that are habitual violators for the serious violations like the DUIs, leaving the scene of an accident, vehicular homicide, and serious violations like that. So I want to go back and address a couple of things that have come up. One is the look back period. And you'll see in 8-285 that there is a 5-year look back on habitual violator. When they're looking at those violations, there's a 5-year look back. And if you look at section 2 of the bill, 8-287, you'll see there is not a look back in that one. So here is what I believe can resolve this in a way to address the things that proponents have brought up, and not to remove the penalties, the mandatory penalties for the other types of habitual violators. And before I get into that, I'd just like to say that there's a reason this provision was put in to the law with these minimums, and that is because the courts were not using discretion to put serious sentences and fines on repeat offenders of driving while suspended. And the driving while suspended was one of the top reasons that people fled from the police and created vehicle pursuits. Right now, it's still one of the top contenders, probably getting pretty close to being matched by people in stolen cars wanting to run from us. So there was a reason that this was put into place several years back, and I think it's important to know that. So here's the solution I think might be there, and that is to restore the stricken language in Section 1 of the bill. To go into Section 2 of the bill, restore that stricken language, add the 5-year look back if you want to. That's I don't think that'd be an issue to us. And then add an exemption to this that mandatory wouldn't apply if the person was suspended solely for failure to pay or failure to appear. And there's a particular statute that's referenced when we make those exemptions. And then I think you should probably go into 8-285 and maybe consider, and I don't know how this would work administratively for DMV, and they certainly would need to weigh in on that, but you could go in and in Section A3 of 8-285, add an exemption to that if that conviction for driving while suspended was based solely on a suspension resulting from the failure to pay, failure to fine, it wouldn't count towards the habitual violator. I don't know what kind of a problem that might cause for them administratively to be able to sort that out, and it may not be practical. I don't know. But I think if we did that, then we would get to the point where we have eliminated this mandatory penalty for those who are suspended and have created these violations because of the failure to pay, failure to appear, and would keep it in place for those serious violators that are habitual violators for their hazardous driving habits and that they continue to drive. And I'll point out, it's in my testimony, but I'll point out that the only way you get to this penalty is, first of all, you have to have committed 3 of those violations within 5 years, listed in 8-285. And then in addition to that, you will have to have been convicted at least 3 times of driving while suspended once you were declared to be a habitual violator. And so, it's a lengthy process to get there, and it's a demonstration of a continuous pattern of them driving in violation of their suspension, not just once, not just twice, 3 times. And so that's where our concern lies. So Representative Proctor, you had asked about other offenses. I think I've covered that the way this is written, it does cover other offenses, serious offenses, and that's where our objection is to it. And I think there was another question about how long people have to pay. I think that's been addressed by some of the other people there, but there's an option in most courts to set up payment plans, and I know there was a bill last year that would have clarified that. And Mr. Chairman, and my final remark is that our associations have worked over the last 2 years numerous times on numerous bills in both the House and the Senate, trying to address this driving or a failure to pay, failure to appear situation. And we have supported many provisions, and we've helped get some language in other bills that narrows the scope of what was being proposed to address that specific issue. So we are not in opposition to what the proponents are trying to address. We're in opposition to the method that this bill addresses it. And with that, Mr. Chairman, I'll stand for questions.
Are there questions? Representative Proctor.
Thank you, Mr. Chair, and thank you, Mr. Clump, for your testimony and for that clarification. So I'm looking at your written testimony, that list of crimes that are fit under the habitual definition, but I'll ask you the same question I asked Mr. Chappell, which is specific to losing your license. What violations of what laws will cause you to lose your license? We've talked about DUI, we've talked about vehicular manslaughter, we talked about, or vehicular homicide, I think. We talked about not paying your fines. Are there any other crimes that would cause you to lose your license?
Thank you for the question. And yes, there are probably too many for me to be able to list without, adequately researching it. But the basic ones related to traffic violations are the ones you mentioned. The DUIs. I think leaving the scene of an accident may have one in it. Vehicular homicide, I believe, has a provision about suspension. The habitual violator, of course, which we've talked about. You could also get your license suspended because of too many moving violations within a certain time period. No insurance can result in a suspension of a driver's license, and I think there are some others that are less, more rare to have happen. But those are I think the bulk of them anyway.
And so, if I could, Mr. Chair, so you're not opposed to removing this mandatory jail time for people who's or third time caught driving with a suspended license if they're suspended for failure to pay fines, but you're not in favor of any other reason that their license was suspended. Is that correct?
That's correct. And so that third violation would be the violation at hand that's leading to this sentence. If that was based solely on a suspension for failure to pay, failure to appear, then yes, we would be supportive of language that would remove this mandatory penalty for that violation.
Thank you, Mr. Chair.
Representative Hoheisel.
Thank you, Mr. Chair. And it's always great to see you. Between this committee and judiciary, you spend a lot of time together. My question is actually for the reviser. Is failure to pay child support, you can get your license suspended for that. Is that correct?
Hey, Mr. Chairman, I will have to look into that. I'm not sure of that.
I do, and Ed, maybe you would know. I do believe it is the case that you can get your driver's license suspended for failure to pay child support. So
I do not know for sure on that one. I know there are several other violations of the law where you can end up getting your driver's license suspended that have nothing to do with operating a motor vehicle.
Are there any further questions? Representative Ballard.
Thank you. We've talked about, a lot of people don't know that you actually can call and get a restricted license. Also, that you can set up a payment plan. That's what we heard from previous conferees. When a person gets their first violation, are they given anything at all that tells them what they can ask for? Or is it an assumption made that they know that?
That's a question for me, Representative Ballard.
Yes, please.
Oh, okay. Those kind of things are things that are done typically in the court, not by the officer roadside. When you talk about options for how you take care of your obligation to the court as a result of the ticket, what we do is we advise them where they need to appear. We advise them what time period they have to contact the court to arrange for either paying the fine or appearing in court. So that's our obligation. We kind of go out, I think, on a limb if we try to describe more than that, because we're getting into a lot of things that have to be determined by the court based on a lot of other circumstances the officer roadside may not know. And so we don't go into that type of detail.
My other question, you were saying you weren't really opposed to 2629 as long as it's based on just the fines and not a DUI or not any of those kinds of things. What I'm trying to think how to word this. For habitual people, and you said whether they have legitimate reasons, and that's determined by the judge at the time. Have we always simply put fine on top of fine? Is there anyone that ever looks at this person got this kind of fine? They couldn't pay the first one. They couldn't pay the 300. Now they have 1,000. Now they have 2,000. Now they have 3,000. If you continually lock them up, how will you ever get your money? Have we ever looked at that as really being more of a deterrent than anything else?
Representative Ballard, law enforcement really has nothing to do with how fines are satisfied. Our obligation is to identify violators and, when appropriate, cite them so they appear before the court. And then it's up to the court to decide, what that penalty is and how they collect that penalty. It's of interest to us because it's important that people be held accountable for their violations. And one of the things with this issue of the fail to appear and fail to pay fine that we've always been interested in is not to eliminate it, because we think, we can't put a person in jail today for not paying a fine. That's prohibited by the case law. But what happens is a person fails to pay their fine or fails to appear in court, they continue to drive even when their driver's license is suspended. So that's new violations that lead to the situation of what we're discussing today, this mandatory penalty in these two statutes. And so it's not really, it's indirectly because they didn't pay their fine, but it's not directly because they didn't pay their fine. They're creating new violations by continuing to violate the law that is trying to hold them accountable in the first place. Okay. So I can't answer. I don't want to answer for the courts, but I do know that in my experience with the courts, the judges are very attuned to the issue of stacking fines and the level of the fines that they impose, and depending on the person's personal financial situation. But at the same time, you have people that's coming back over and over and over and over again on new charges because they're continuing to drive in violation of the restrictions or suspensions that have been placed.
Thank you. That was very helpful. Thank you. Thank you, Mr. Chairman.
Any further questions? Revisor, there's a question for you.
Not a question, just I think you got an answer to the question.
Yes, thank you, Mr. Chairman. To Representative Hoheisel's question on the child support, I did find the statute that if a person is found guilty of contempt in a child support enforcement proceeding, the court may restrict the driver's license by contacting the Division of Vehicles and restricting that person's driver's license.
One clarifying question,
Okay.
if I may, Mr. Chair.
Go ahead.
You said restricted. Are we talking about they fall down to a restricted license, or their license is in effect suspended?
It says restrict, and I'm sorry, I can't go beyond that, but that's what the statute says, restrict the obligor's driver's license as indicated in the court order. So presumably that could go to a suspension.
Mr. Chair, I do have one request at an appropriate time from research, if I may.
Sure.
I'm wondering if we can gather all the data of current suspended driver's license in Kansas, if this is possible and feasible. Just the number of suspended driver's license and the reason of the suspension of the driver's license. I'm just curious if we're seeing a number of these suspended driver's license because of failure to pay, or suspended driver's license for failure to pay child support, just the reasons for it and what we're actually trying to cover when we narrow this bill down. So if that's possible from research, I would like to see that data, Mr. Chair.
Thank you. Today, I bring your attention to written testimony in opposition from the Kansas Highway Patrol. I have no neutrals listed. Does anyone wish to speak as a neutral? Not seeing one. We will close the hearing on House Bill 2629 in committee. If a compromise is worked out, we may end up holding a meeting on Monday, because that'd be the last day we can hold a meeting. So just please watch, and we'll see what comes down for us then. With that, we are adjourned.